उनको फोन करिए शालिनी मैम को अगर हम स्टार्ट करें. Unmute करिए. Honorable the Chief Justice, Justice Ravi Shanker Jha, Punjab and Haryana High Court, all other dignitaries and respected audience, good morning to all. It's a matter of immense pleasure and indeed a great privilege for me to welcome you all today on this online workshop on behalf of the Juvenile Justice Monitoring Committee, Punjab and Haryana High Court, Chandigarh. Under the kind patronage and guidance of Honorable the Chief Justice, this online workshop is being organized. Let me tell you that it is basically the Chief Justice who motivated us to have this online program for the reason that during the process of certain discussions, it was found that probably we are lacking on certain fields. The new amendments which have come in have also not really percolated and are not being given effect to. There were certain shortcomings which were pointed out during the process of various stages of the trials. And these things were to be taken care of. With the Chief Justice taking keen interest into the working of the authorities, who believes in spreading awareness, not just to the general public, but to one and all, and especially about the various changes which come in, so that the knowledge and acumen of the members is continuously enhanced. This was the intention with which the whole program has been chalked out, planned, and now it is the stage when we are about to start the program. We would assure the Chief Justice that we are making all endeavors and under his kind, active and inspiring guidance, we'll make everything possible as far as workable. Our endeavor is to fulfill the objective of the Juvenile Justice Act. Honorable the Chief Justice, who is with us, he doesn't need any introduction as such, but I would just point out that he is a wonderful person who thinks about others before himself. And that was apparent when we had that period of COVID. The amount of care he took of others, in fact, it was, I must say that I was really amazed of that. But nevertheless, if he is such a person, obviously the concern for the juveniles is paramount in his mind. And therefore, this program all the more is important for that purpose. We are grateful to Honorable the Chief Justice to have accepted our invitation and having agreed to start the occasion for us and preside over the function as such. We are grateful to him from his busy schedule. He has given us some moments, and we are sure that his pearls of wisdom, which he's going to share with us, will be a great help for all of us to understand as to the new amendments which have come in and the effects thereof. Thank you very much for everything, Chief Saab. May I now request Chief Saab to please enlighten us with his thoughts. Thank you, Chief Saab. Thanks.
Thank you, Brother Masih. Thank you for the wonderful, kind words that you've spoken about me. Good morning to all of you. Good morning to Brother Singh, who's chairing the committee. Good morning to all the chairperson and members of the Juvenile Justice Monitoring Committee, principal magistrates and members of the Juvenile Justice Board of the state of Punjab and Haryana, all magistrates, chairpersons and members of child welfare committees, police officers of special juvenile police units, probation officers, officers of Department of Social Welfare, Women and Child Development Punjab and Haryana, and all stakeholders under the juvenile justice system. Good morning to all of you. I must, at the very outset, acknowledge the fact that the Academy, as well as the Committee of the High Court, took immediate and prompt steps in view of certain judicial issues that had come up before the court, especially relating to trial of juveniles and the necessary induction training which is mandatorily required under the provisions of the Act. So as all of you know, Section 4, Subsection 5 mandates that there has to be an induction training for the magistrates who are the chairman of the boards. Subsection 6 of Section 4 requires that the members should have induction training before they undertake their responsibilities. Section 107 of the Act requires special training for the child welfare police officers and the special juvenile police units, all of whom are stakeholders and all of whom are very important members and authorities, in fact, who are to ensure proper implementation of the projects, the objects, the provisions, and the orders that are required to be passed under the Act. Now, initially, I was thinking that I would give you a little bit of an overview of the amendments made in the year 2021, but I find that the workshop has been organized in a wonderful way, and the very first session itself would be a detailed one where you would be introduced to the major changes that have been made in the Juvenile Justice Act in 21. Thereafter, the topics that have been chosen regarding implementation of Section 15, conflict in grant of bail to conflict juvenile in conflict with law, then these other issues regarding determination of age, functioning of the child welfare committees, role of police officers, etc. So I don't think that I should do or tell you anything about these things. I would just give you an overview of the whole system so that perhaps you can look at it from my perspective. You see, this as far back as in 1833, a young boy was sentenced to death for stealing 2 pennies in England. In 1833, not 1833. In 1834, a special police, a jail was constituted in Parkhurst in the Isle of Wight for juveniles, which was where they were kept in chains and they were guarded by armed people. In 1875, a 13-year-old girl was sent to jail for not paying fine. Now, these were the things that were happening there, which actually led to first the Apprentice Act of 1850 being promulgated, which was not dealing primarily with juveniles, but did have minor provisions relating to engaging juveniles for a bond period of 10 years to take them away from this life of crime. In 1864, a whipping act was formulated. The object was to administer public punishment to juveniles, which would deter them from indulging in a life of crime and perhaps would not later on be required to be rehabilitated. Now, all these things, then in 1897, the Reformatic School Act came up. Ultimately, in 1908, the first Children's Act which constituted juvenile boards and others were constituted. Now, the very object and purpose was to do away with excesses against children who had perhaps committed a crime without knowing what they were doing. And the object was to bring them back into the mainstream. And this object and purpose remains the same till date. Whatever the amendments that have been made from time to time in the acts governing our system, including the 2021 Act, the mandate is, as far as the children who are in conflict with law is concerned, it is rehabilitation and bringing them back into the mainstream. Now, why I pointed this out was it's necessary for you to understand that basically whenever these workshops are held, they become more children oriented. Like emphasis is we must help children. Children are the future of the country. Children are this. You must understand that we are not dealing with the entire broad spectrum of children here. We are only dealing with children who are in conflict with law. And now after the 2021 amendments, the aspect of adoption has also been taken out from the purview of courts. Under the 21 amendments, now the entire process of adoption is to be taken up by the magistrate, district magistrate and others, and whether that's correct or not is something else. But the fact remains that as on date now, as far as judicial officers are concerned, they have nothing to do with adoption. So now the problem comes up with us is that when we have a board, judicial officers and members manning a board who deal with a juvenile who's in conflict with law, a child who's in conflict with law and is brought before him, how to deal with him? Now, the issues involved here have been delineated greatly in the Act, but there are certain features that are missing. To my mind, firstly, the board must look at the present situation of the child brought before him, before the board. Then it has to examine minutely the past and thereafter determine the future action that is to be taken against this child. And for this purpose, it's absolutely necessary that if you go by the provisions of the Act, you'll find that when a child in conflict with law is first apprehended, it's the first person in contact with such a child is the child welfare police officer who is designated by the state, who has to be child friendly person, so and so. You find somebody or a child is arrested, is the child welfare police officer who is the first contact with this child, and it is his job to produce this child before the board. Now once he does that, the board is not required to take immediate action against this child or take a decision in respect of what is to be done with him. What is most importantly required to be done is they have to call a report from the probation officer, which is known as the social investigation report. Now, this call for the social investigation report from the probation officer, or if the probation officer is not there, then is the child welfare officer, which is again attached to child care institutions and has to be designated by the state government. So the first inquiry that has to be done by the board is to find out the past. And then it's only after considering the social investigation report that you to determine what is to be done. Then the age part comes in, whether it's to be sent to some other court or whether you have to deal with it and other things. Those come later. But what I was trying to emphasize is that since the object and purpose of this act is rehabilitation, the object, you see, once a child is found in conflict with law, he does not become somebody who has to be dealt with by the judiciary or the board or any committee for his life. It's only up till the age of 18 years. So what you have to look at is how do you rehabilitate him? How do you bring him back into the mainstream? And for that, it is very important to know his background, because most of the children who indulge in crime, they come from a background of crime, either their parents or the social setup in which they are staying. It actually pushes them, inculcates them into a life of crime. See, I'll tell you an instance which we had maintained a record in Madhya Pradesh when I was there. We came across a child who had been apprehended 74 times as a juvenile and had been left by reprimanding him. By the time he became a major, he was a hardened criminal. 74 times he commits a crime. You simply say, catch his ear, don't do it again, and leave him. You see, you fail in the object of the act. Because what you have to do is to see that this child has to come back in the mainstream. You can't, it's not that you have to just handle these people, these children with kid gloves and let them go without punishing them. No. The most important role of the board is to see that the child does not go back to it. Now, suppose you just give him and say, okay, don't do something, go back. And if he goes back to the same environment, which has actually pushed him into a life of crime, the child is not going to come out of it. There's no rehabilitation. And this is where the most important part of the board comes in, that you to look at the background, call the parents, examine the social setup, you have to even counsel the parents, or you have to take action through the probation officers, or the child welfare officer, or the SGPU, or the police officer concerned. And thereafter, you have to make sure that the child comes back into the mainstream by doing whatever. There's so many things. I need not go into it because I'm sure in the workshop, so many things will be placed before you and you will come to know about them. So this is one very important aspect which I find is missing in all the workshops that we conduct. And therefore, I thought I'll just bring it to your notice that you have to make sure that you don't consider yourself NGOs who are dealing with the entire spectrum of children and their upliftment, but you are dealing with a very narrow, small population of children who are in conflict with law. Or if it's a question of child welfare committee, these children who are in need for care and protection. It's only this small spectrum, number one. Number two, the job is not to see that they are just let off and dealt with lightly, but to see that they are rehabilitated and brought back into the mainstream of society, that they live a life of crime for which you have to go and delve into their past and other things. Other aspects would, I am quite sure, be taken up in the workshop, and I don't think I need to go into that. I once again congratulate all the stakeholders and others who have immediately responded to this workshop and are here to help all of us, each other, to implement the provisions of this act, as well as the academy, and especially the committee of the High Court, the Juvenile Justice Committee, Monitoring Committee of the High Court, which has taken prompt steps to see that these things are taken up. Anxiety, as I told you, was mainly two things. One is we found several cases where juveniles were being tried by regular courts in criminal cases without the people having knowledge of the fact as to how to deal with them. And secondly, the magistrates have to be statutorily provided and had to undergo an induction training, which was missing. So the magistrates, the members of the board, the police officers and other authorities who are part of the system need to be inducted into this. And that is why the object and purpose of the exercise of the workshop. I thank all of you for participating in this. I wish you all the luck and success. And I once again laud the effort taken up by the Juvenile Justice Monitoring Committee and the Academy. Thank you. Thank you.
Thank you, Chief Saab. Thank you very much for your beautiful words and encouraging words, and the outline which you have given to us. In fact, that would be the line on which we'll be towing in this whole seminar. Thank you, Chief, for everything. Thank you. Thanks a lot, Chief.
Thank you.
Thank you. Thank you, Chief. Thank you so much.
Thank you.
I now call upon Dr. Balram Gupta to please take over and take the session further, please. Dr. Gupta?
Connectivity issues as usual.
Yes, Dr. Gupta, we are waiting for you to take over now.
Thank you so much, Honorable Mr. Justice Masih and Honorable the Chief Justice for delivering a penetrating address in regard to the Juvenile Justice Act. The first session we are devoting to the major changes which have come in through the statutory process which has been carried out right from the year 2020 as such. Over the period, certain changes have been brought in, which ultimately culminate into making the whole juvenile justice system wholesome as such. This particular session would not only be allocated with regard to the major changes, the fair, speedy inquiry under the Act would also be the focus of the first session. This first session would be taken by Mr. Baljinder Singh Sra, Judge, Children Court, Bathinda. Mr. Sra is a blend both as a lawyer and also a judge. He was selected into the Superior Judicial Service, Punjab, in the year 2016. He was with the Chandigarh Judicial Academy from the years 2018 to 21. And he also, while being on the faculty, was seriously into the different programs which were conducted in regard to the Juvenile Justice Act, for that matter. He's also an accomplished author, and therefore this particular session is being managed and carried out by Mr. Sra as such. I call upon Mr. Sra to take over the first session as such.
Thank you so much, sir. So much for the kind words which you have said about me. I don't know whether I will be able to live up to that expectation. First of all, I would like to thank Honorable Chief Justice for conceiving the idea of organizing this workshop. I'm also thankful to Honorable Mr. Justice A.G. Masih, Chairperson, Juvenile Justice Committee, Honorable Mr. Justice Amol Ratan Singh, and Honorable Ms. Justice Jayashri Thakur, who is also one of the speakers in the third session with us. This workshop was long overdue for the reason that the Act itself mandates the imparting of training to the board within 60 days of their being appointed as such. Now, so far as my lecture is concerned, I would like to first say that Honorable Chief Justice has summarized my entire one hour lecture in few minutes and has given the not only the brief introduction, but rather the entire nuances and semantics of the Act itself. So I am thankful to Honorable Chief Justice for making my path more easier. Now, so far as this Juvenile Justice Act is concerned, probably after the enactment of the Act of 2015, the stakeholder missed the spirit of the Act. As rightly said by Honorable Chief Justice, the spirit of the Act remains the same. That is how to reintegrate and rehabilitate the children who have come in conflict with law. The idea is not to punish them proportionately to the gravity of the offense committed by them. The long title of the Act bears testimony to this fact that the Act has been, consolidates the law relating to children who are alleged and are found to be in conflict with law, to provide them better care, protection, treatment, development, and further reintegrate them and rehabilitate them back into the society. Now, while doing so, the Act itself unfolds that the best interest of the child is to be secured. Now, notwithstanding the history and the reasons for enactment of the Act of 2015 from its precursor Act of 2000, now this Act has introduced certain radical changes vis-a-vis the precursor Act of 2000. Now it has introduced the segregation of the offences unlike the previous Act. Now we have the categorization of the offences into petty, serious and heinous. Now the idea is not to punish the children who come in conflict with law. The idea is to have graded interventions by the board and the other stakeholders depending upon the nature of the crime in which the child get involved. The second novel feature of this Act of 2015 is that there is a transfer hearing under Section 15 of the Act where the board is required to make inquiries into certain aspects of the child to decide whether to transfer the child to the children court for further proceedings or to retain it with itself and proceed accordingly. Now, prior to this workshop, I would like to share that the Chandigarh Judicial Academy conducted an exercise by calling the orders from the principal magistrates of the board from across the state of Haryana and Punjab. And while analyzing those orders, deficiencies have come to the fore. That somewhere or the other, the stakeholders are missing the spirit of this Act. And they are trying to take the Act in a fashion that the children in the age bracket of 16 to 18 years who have alleged to come in conflict with law, they are to be punished just as an adult. So there is a hostile attitude and mindset while dealing with these children. So let me share with you that children are different from adults. There is a penological justification for treating the children differently. They are less mature. They have less control over their circumstances in which they are placed, and they lack the ability to extricate themselves from those circumstances. And their traits are not well formed, just like in case of adult. So children are just children. Incorrigibility is inconsistent with the youth. So therefore, we should not have the mindset that the children who come in conflict with law will remain incorrigible and treat them as hardened criminals and then punish them according to the gravity of the offense. That is not neither the object nor the spirit of the Act. Now I'll commence with the PPT also, share with you the PPT which I have prepared, and I'll elaborate the overarching principles So I'll first give you a short overview of the key changes brought about by the Amendment Act of 2021, though these have been some of these have been already elaborated by the Honorable Chief Justice. That so far as adoption orders are concerned, the powers have been transferred from the judiciary to the district magistrate and additional district magistrate. They are to decide on all these things. Then the order of the Child Welfare Committee, which was earlier non-appealable in respect that where it reaches a decision that whether the person is not a child in need of care and protection, these orders have been made appealable. There was a deficiency in the drafting of the provision relating to the definition of serious offences. This has been ironed out in view of the judgment of the Honorable Supreme Court. So now what we have is that except offences where the minimum punishment prescribed is 7 years, all other offences have been put or in the category of serious offences, leaving aside the petty offences. So earlier there was a deficiency in the definition of the serious offence, and even those offences which were serious were being children were being transferred to the children court by the board. Then the another change is that all offences against the children are now to be tried by the children court, unlike the previous situation where there was gradation that offences up to 3 years were to be tried by the JMIC. Next is that there is a slight change in the nature of the offences against children. Now the offences punishable between 3 to 7 years will be cognizable and non-bailable. Now such offences will be non-cognizable and non-bailable. Then there's a slight change in the criteria for becoming the member of the Child Welfare Committee. So these are the key changes which have been brought about by the Amendment Act of 2021. Now I'll just shift to the move on to the main part of the Act. Now, so far the Act is concerned, it confers exclusive jurisdiction and tends to override all other provisions or other inconsistent laws, and it shall apply to all matters concerning children in need of care and protection and children in conflict with law, including their apprehension, detention, prosecution, penalty, rehabilitation, reintegration. Now, there are certain overarching principles. The legislature has taken care to provide for overarching principles in Section 3 of the Act, which will act as guiding principles for all the stakeholders while implementing the provisions of the Act. Now, I would say that these principles would serve as a pole star whenever the children court or the principal magistrate are in a fix and lose direction or come across certain situation where they find that which way to go. So these overarching principles would be very helpful to them while interpreting as well as while implementing the provisions of the Act. Now, the first principle is principle of non-stigmatic semantics. Now, I would say that this Act itself is with a different theme as well as different semantics. Throughout the Act does not use adversarial or accusatory words. And otherwise, if one read the Act in a holistic way, one will find that the Act is a non-adversarial piece of legislation. The main object of the Act is not to punish the child who has come in conflict with law, but to provide intervention by all the stakeholders for his rehabilitation and social reintegration. Now, in this principle, you would notice that instead of the word police officer, we have the child welfare police officer. Then instead of word trial, we use the word inquiry. Similarly, child welfare officer. So the entire semantics of the Act, you would notice, is non-stigmatizing. Now, while interacting with the board members, with the principal magistrate prior to this workshop, certain board members were a bit confused that while implementing the Act, they are facing some difficulty that they are not able to pass certain orders which are required in a given situation. So let me assure you that the semantics are different, but the powers given to the board and the children court is immense in order to achieve the objective of the Act. This will be unfolded during the course of the lecture also, but rest assured that notwithstanding the semantics, they should not get bogged down by the different semantics used in the Act, and they should feel that they have been empowered to such an extent that where in a child-friendly manner, by adopting certain techniques, they can implement the provisions of the Act. Now, the second overarching principle is the principle of presumption of innocence. Now, it says that any child shall be presumed to be innocent of any mala fide or criminal intent up to the age of 18 years. Now, here also, the question arises that there are certain special acts, penal acts, incorporating reverse onus clauses, where there is a presumption regarding the mens rea as well as certain physical acts, which helps the prosecution in proving a given offense. Take the example of POCSO Act. Similarly, we have NDPS Act. There are certain other acts also where you'll find reverse onus clauses. Now the question is, when in case of conflict between this principle and the provision of reverse onus clause in a given penal act, which one is to be prevailed? Now, though I'm not supported by any judgment of the Constitutional Court as such, but to my mind that since this act deals with a special class of persons, that is children up to the age of 18 years, the provision of this act would prevail over those presumptions. So the children court as well as the principal magistrate, while undertaking the inquiries against the children in conflict with law, should presume the innocence of the child. Now here there is another aspect also, because while conducting the transfer hearings under section 15 of the Act, what we are finding is that invariably in all the offences categorized as heinous offences, the board are transferring the children to the children court for trial as an adult. Now this is a strange situation and probably they are missing the spirit of the Act. Invariably, they are being guided by the gravity of the offense, and they are not able to appreciate that they are dealing with a special class of persons, and they should not be robbed of their childhood by mechanically transferring them to the children court to face trial as an adult. Now, I'll take two examples to elaborate this point regarding the principle of presumption of innocence. Take, for instance, the offences involving physical violence, which could be the case under section 326 IPC or 302 or 304, whatever it is. Now, the Act mandates in section 15 that the circumstances in which the child got involved in the offence is also one of the key factors which is to be evaluated by the board exercising the discretion under section 15 of the Act, whether to transfer the child to the children court or to retain it with itself. Now, in all these situations, the board members must keep in mind that the principle of constructive penal liability under section 34, 149, or maybe any other provision of the law, in all these situations where the child has only played a peripheral role in the commission of the offence, they should be retained as a child with them. They should keep in mind that the presumption of innocence is an overarching principle under section 3 of the Act, under this Act. So the case of transferred malice or transferred intent under section 34, 149 and all that should not generally or usually be applied to the children in conflict with law, and the board members are urged to take this principle or bear this principle in mind while holding the transfer hearings under section 15 of the Act. Take another example, offences involving NDPS cases. Here also the experience has shown that whenever a child is found in possession of the contraband under the NDPS Act, it involves commercial quantity. They're also being invariably transferred to the children court to face trial as an adult. Now, I would like to bring to the notice of all the stakeholders that under the JJ Act, there are two provisions, section 77 and 78, which carves out offences relating to children. 77 says that anybody who supplies narcotic drugs or psychotropic substance to the child would be punishable with 10 years imprisonment and so on and so forth. 78 says that any person who employs the child into trafficking of narcotic drugs and psychotropic substances would also be punishable for the period of 10 years and so on and so forth. Now, what is happening is that the child welfare police officer, when he apprehends the child under the NDPS case, he is not making any investigation, any inquiry from the child that how he got involved in trafficking drugs. Is he a drug addict and carrying the drugs? Has he been given some allurement by some third person to involve into this? So, and invariably the child welfare police officer are not booking these people who are employing the children in trafficking drugs under the JJ Act. These offences are not being added. With the result, what is happening is simply a child is being produced before the board that he was found in possession of the drugs, and if it is of commercial quantity, the board is transferring the child to the children court for standing trial as an adult. So remember, they said that presumption of innocence is very important, and it's an overarching principle which has to be borne in mind while dealing with all the inquiries under the Act. Now, the third principle is principle of participation. Now, this is also a problematic area so far as the state of Punjab and Haryana are concerned. Prior to this workshop, I also happened to have interaction with certain principal magistrates of the state of Madhya Pradesh also. Now, in Punjab and Haryana, what is happening is that this principle is not being implemented in its right spirit. Whenever a child is being produced before the board are not holding interaction, are not preparing any questionnaire to find out how the child got in conflict with law. Now, why I'm saying so is that this interaction are confidential in nature. Some of the board members in the interaction raised the question that can we put the straight question to the child when he is produced before them regarding the commission of the offence? Answer is yes, because once you take the child in confidence and interact with the child is going to speak the truth. He's going to tell us how he got involved into the offence, what offence he has committed, and all other factors. It depends how well we establish the connection with the child. But these questionnaires are to be put in the sealed cover or should be given the confidentiality and would not be used while undertaking the inquiries to decide upon whether they committed the offence or they didn't commit the offence. So these should be interacted. These are really helpful to them in adjudicating whether to retain the child, especially in respect of the heinous offences, with them or to transfer the child to the children court to face trial as an adult. So this overarching principle says that every child shall have a right to be heard and to participate in all the processes and decision affecting his interest. Now, this is equally applicable to the children court, where more or less as of now, the mechanism being adopted is that of an adversarial trial. The trial is being conducted just like that of an adult, and at the end of the day, what is happening? We are sentencing them to long term, like 20 years and so on and so forth. I give you one example that cases have come before us. In case of adolescent sexual behavior, that two children who are in an affair and the boy is being tried for the offence under the this 376 IPC and all that. So what is happening? The board, irrespective of this fact that he's a child, is transferring the child to the children court. Children court is sentencing the child to 20 long years. probably one can imagine the plight of the child who's being sentenced for a behavior which he may not be knowing that is either in is conflict with law, or it's a natural human we can say urge at the age of adolescent to experiment and all that. So therefore, all these things should be kept in mind. The principle of participation is very material. Then next overarching principle is principle of best interest. Even in the long title of the act seeks to secure the best interest of the child. So this principle says that all decisions regarding the child shall be based on the primary consideration that they are in the best interest of the child. Now, one can't say that putting him in long years of imprisonment for 20 years, for life, is in his best interest. The best interest would be that we find out the causes, the reasons, the circumstances which resulted into his coming in conflict with law, and try to remove those and help him to build the capacities to overcome those difficult situations, and then get reintegrated and rehabilitated back into the society. Next is principle of diversion. This principle is also one of the important principles whose reverberations we find across the Act. Now, this principle of diversion says that as far as possible, the children who comes in conflict with law, the resort to judicial proceedings should be minimized. So the judicial interventions is to be done only in limited cases, or unless it is in the best interest of the child or the society. Now, we find its reflection in Rule 8 of the Model Rules 2016, which have to be read along with the Act. Now, what does the Model Rule says? It says that the Child Welfare Police Officer will not register FIR in case of petty offences and serious offences. So, unless the adult is also involved, in which case FIR has to be there, because the adult is also involved in the offence. But where the adult is not involved and only child is there, then the rule mandates that the FIR should not be registered against the child. Only DDR should be recorded, and thereafter the proceeding have to be conducted as per the provisions of the Act. Next is the principle of right to privacy and confidentiality. So the privacy of the child has to be protected. The interactions which the board and the children court will conduct with the child, those have to be kept confidential. And even the reports which are being furnished by different other experts in respect of children are to be treated as confidential by virtue of Section 99 of the Act. And principle of fresh start. Now, this is probably captures the theme of the Act, that all past records of the child should be erased except in special circumstances. Now, while interacting with one of the principal magistrate from Madhya Pradesh, I came across one of the difficulty which the children were encountering, that once their inquiries are over in respect of petty offences and serious offences, they sometimes face difficulties in their rehabilitation or in getting job in future. And the police officers, they used to reflect the conduct of such proceedings, the commission of these offences, in their character roles also. So while getting the character certificate from the police, they were facing immense difficulty. Now, this judicial officer started issuing one certificate to the juvenile at the time of disposal of the inquiry, recording clearly that this inquiry shall never be reflected by the police officer while issuing the character certificate to the child who has come in conflict with law. And this was really helpful to them while seeking employment, public or private, in the later course of their life. I'll show you the certificate also, how it has been prepared. Next is the principle of repatriation and restoration. Now, this principle, overarching principle, would find its reverberation in section 12 regarding the grant of bail. Now, most of the Juvenile Justice Board are under this misimpression that the bail of the child is to be considered only when he will file the application. The answer to my mind is no. It is rather the duty cast upon the board once the child is brought before it to apply its mind, because the word used is shall over there, to grant the bail as far as possible, because that section 12 also incorporate this principle of repatriation and restoration to the family whenever the juvenile is brought before the board. And only in few circumstances, which are also meant to secure the best interest of the child, only then he has to be given or put up in the institutional care in order to provide rehabilitated services so as to help him to reintegrate and to restore him back to the society when he gets reformed. So this principle says that every child shall have the right to be reunited with his family at the earliest and to be restored to the same socioeconomic and cultural status that he was before coming under the purview of this act, unless it is not in his best interest. Now, this principle would definitely be discussed in detail in the third session while dealing with the provision of bail and all that. Now, this is the certificate prepared, or I would say innovated by the principal magistrate who has now been holding the children court also in MP. Now, she has prepared this certificate in Hindi, but the Academy has translated this in English for the benefit of our principal magistrates. This certificate is not there under the rules, but has been very helpful to the children while seeking re-employment after their inquiries are over from the board members. And next overarching principle is the principle of institutionalization as a measure of last resort. I've already said that the act mandates that the child must be restored to the family, and even in case of child in need of care and protection, he should be placed in the family setting, and the institutional care is the step of last resort. The next is principle of non-waiver of rights. It simply says that the child is not capable of making a choice to waive off the right under the act. So at no stage he's entitled to waive off the right. So therefore, the duty is cast upon the board and the children court to ensure that all the rights of the child are taken care of while conducting inquiries under the act. So simply because the child did not make a plea, or child is not given proper legal aid, or even if given legal aid, he missed on certain important rights. So that principle of non-waiver would still protect him, and its effect can be examined by the courts. Next is the principle of equality and non-discrimination. So this simply says that there shall not be any discrimination against a child on any of these grounds. Then next principle is principle of natural justice, which are required to be followed, with the added advantage that in case of children, the special procedure which is given in the act has also to be adhered to, like the participation of the child at every step and in every decision affecting his interest is also required to be followed by all the stakeholders. Then principle of dignity and worth, that the child, simply because he's a child, does not mean that he's not a human being, and his dignity and rights are required to be protected, and they are the vulnerable class of the section of the society who may not be able to look after their interest. They are more amenable to the external influences, outside pressures, and moreover, at this age, since all of us have grown out of this age, we all can both say for this fact that the singular traits of childhood, they wither away with maturity. So, and what are these singular traits? Impetuosity, recklessness, risk-taking factors. So all these traits which are there in the children have to be taken into mind while adjudicating their rights under the Act. The last is principle of family responsibility. So the primary responsibility to take care, nurture, and protection to the child is that of biological parents or adoptive or foster parents, as the case may be. Then we have principle of safety and positive measures, which are to be mobilized by the society in general and the stakeholders in particular to ensure the best interest of the child. Now, for the board members, in order to allay fears, because the way they are conducting the inquiries is not probably what is being envisaged under the Act. Now, I've put this in Form 12, Rule 12, Sub-Rule 2, how the inquiry is to be proceeded by the board. Invariably, during interaction, I have come across that the child welfare police officers are not filing social background report. As our Lordship rightly said, that the first responder or the first persons who would come in contact with the child in conflict with law are the special police, child welfare police officers. Now they are required to make a social background report in form number 1, giving the entire circumstances, eliciting the questions. They are required to interview, because I've said that the semantics used in the Act are different. So therefore, instead of word interrogation, the Act uses the word interview. So the child welfare police officers are required to interview the child, elicit all the circumstances which led him in conflict with law, and while preparing the social background report, they should be careful in defining the role of the child while committing the offense, as well as the other social background of the child, which made him vulnerable and led him into the commission of the offense. Now, the second part you will notice under this form is consideration of bail. The moment the child is brought, the time period is 24 hours. The board is obligatory under obligation to consider the grant of bail, because Section 12 itself mandates that the child shall be granted bail except in the 3 situations, which also incorporates the principle of best interest of the child. Now, the age determination factor, if there is some dispute arises regarding that, then they are required to call the social investigation report from the probation officer or the child welfare officer or the social worker, then final report, then investigation, then the remaining procedure is just general. Individual care plan. One of the query raised during those interactions was that when the child is brought before the board, can the board undertake the rehabilitated services at the initial stage, or they are required to wait till the conclusion of the inquiry and then prepare the individual care plan? Then the answer is they are required to undertake the rehabilitated services at the very, we can say, initial stage itself, when the child is being brought before them. Now, so far as individual care plan is concerned, the Act says that at the time of passing dispositional order, it shall. So there it is mandatory. There the intervention is mandatory, but that does not foreclose the option with the board members to start with the rehabilitative services at the very initial stage. And I'll refer to certain rules also, which would both say for this. Then this is also one of the important part so far as board is concerned, because since the judicial officers, they are conditioned and trained in the adult criminal justice system they get bogged down by the different semantics used under the Act. Because some of the board members, they felt that they're powerless as they don't have the powers to pass certain orders. So I'm sharing with you that don't get mistaken by this. The Act confers immense powers to effectuate the purpose and the object. Section 4, subsection 2, confers the power of Metropolitan Magistrate or JMIC on the board, which leads to implication that they have all the powers which a magistrate can exercise during conduct of the trial in regular courts. They can use this power under 319 CRPC. They can order further inquiry. They can disagree with the report of the child welfare police officer and discharge the child by taking the rehabilitative measures if required. They can adopt coercive measures to secure the presence of witnesses, because this was also one of the area of concern shown by the board, that they're not able to secure the presence. They can take all these measures and they can exercise all other powers conferred upon them under CRPC, which are moderated by the principles and of the Act by using different semantics. For instance, in case of missing children, those who are absenting themselves from the inquiry, some of the board members said that the child welfare police officers are saying that without the issuance of arrest warrant, they cannot bring back the child. The answer is no. Arrest warrants are not to be issued. Instead, they can issue the apprehension order, which will have the same effect. So therefore, by using different semantics, they'll be able to achieve the required objective, required purpose in a given situation. Now, I'll refer to section 8, delineating the responsibilities and function of the board. First is participation. While undertaking inquiries and different steps, the board is required to ensure the informed participation of the child, the parent, guardian at every step of the process. And this is this would be equally applicable to the children court also when they undertake the steps under the Act, whenever the child in conflict with law is transferred to them. Then next is they're required to protect the child rights at every step. They're required to ensure free legal aid to the child. Then they have to call for the social investigation report within a period of 15 days from the date of first production. But remember this thing, that for the purpose of bail, this report is not required. For that, the report required is social background report, which the child welfare police officer is required to put in on the very first date when he will produce the child in conflict with law before the board. Then transferring children where the child in conflict with law generally is a child in difficult circumstances. So it may be a situation where he also is a child who is covered under the ambit of in need of care and protection. Then for those matters, the board can transfer the matter to the child welfare committees. Then providing rehabilitative services in dispositional orders. Then inspection of the different residential facilities. Registration of FIR. Now, I was just referring to the powers of the principal magistrate. Now, under the rules, it is clearly mandated that whenever an offense is committed against the child, suppose a child in conflict with law is produced before the board, and during interaction, it is found that there is an offense which is committed against the child, then they can order the registration of the FIR. And in case of children in need of care and protection, on the written complaint of the child welfare committee, the board can order the registration of the FIR. Then regular inspection of jails meant for the adults to check out if there is any child in conflict with law lodged there. Then procedure, I'll just skip this part because this part will be covered by my co-speaker, Mr. KP Singh tomorrow. Then, as I alluded to this Rule 8, principle of diversion, that no FIR is to be registered except where a heinous offence is alleged to have been committed by the child, or where such offence is alleged to be committed jointly with the adults. So in these cases, only DDR is required to be recorded. Then social background report is required to be filed by the child welfare police officer, and there's a limited exercise of power of apprehension. Even in case of heinous offences, the child welfare police officer has a discretion not to arrest if it is in the best interest of the child. So in all cases involving petty offences, serious offences, the power of apprehension is not to be exercised, and other measures are required to be taken. Then information to the parent, guardians, probation officer is required to be made. So I'll just shift on to this part because I'm short of time. Probably this is section 14, dealing with the inquiry by the board regarding child in conflict with law. Now, this part is very important because this is leading to certain other critical issues which may require resolution at the hands of the constitutional courts at some point of time. Now, in the ideal situation, if we examine the provision, section 14 provides for a speedy inquiry, speedy justice to the children who come in conflict with law. It sets out the outer limit to conclude the inquiries or different other proceedings under the Act. Now, the total period provided is 6 months. 4 months is the original period and 2 months is extended period for completing the inquiries by the board. Now, this limitation is not being adhered to if the evaluation is done in the state of Punjab and Haryana. So invariably, this is a problematic area that this limitation is not being adhered to. And to top it all, the inquiries are not being terminated, despite there being a clear mandate under the Act that if the board is unable to complete the inquiry within the period of 6 months, the proceedings shall terminate. But despite that, they're still continuing. It's a wake-up call for all of us to adhere to this provision that in case of petty offences, those should not be continued and those should terminate. I'll refer to certain rules also, where in case of petty offences, the rule says there is no need for the board to wait for the final report and they can dispose of the inquiry at the very first stage itself by undertaking the rehabilitated services which are required in a given situation. Now, in respect of inquiry pertaining to serious or heinous offences, if the board requires further extension, they are required to apply to the CGM. And while extending the time, the CGM is required to record the reasons in writing. Now, this is also not being followed to my mind, and the inquiries are still continuing for longer durations without seeking any extension from the CGM. And probably there's a provision under the Act where the CGM is required to make the inspection of the into this aspect. But I'm doubtful whether this is being done or not. Now, for preliminary assessment, the time period is 3 months from the date of first production of the board. Now, this provision is also not being followed, and we are coming across cases where after 2 to 3 years, certainly the board has woken up and found that they were required to make the preliminary assessment under section 15 of the Act, and they are transferring the child to the children court long after 2 to 3 or 4 years also. And this has serious repercussions. I'll tell you how this will be encroaching upon the rights of the child. Now, if you examine the entire mechanism under the Act, the legislature has taken care that children, even who are accused of committing the heinous offences in the age bracket of 16 to 18 years, timely interventions should be taken by the stakeholders to reform them and restore them back into the society. Now, take for instance, a child who is about to touch 18 years is alleged to be have committed a heinous offence. That child is produced before the board. Now, Section 15 mandates the time period of 3 months to complete the preliminary assessment. Now, if this is done on time, and assuming that the board has transferred the child to the children court to try as an adult, the children court is required to make the reassessment. After making the reassessment, obviously there is also the provision for filing the appeal. But let us suppose that children court also comes to the conclusion that the child is required to be tried as an adult, and it concludes its trial, and let us say punish the child in conflict with law, let us for 10 years or 20 years, whatever it is, depending upon the nature of the offence. Now, if this entire thing is done on time, then Section 20, which is very, very important section and provides a second window to the child in this age bracket 16 to 18 years and who is also accused of committing the heinous offence to undergo reformation. This will be missed. If I'll elaborate this point while dealing with the topic in my next lecture, that how this is important. Because there is no automatic automatic transfer of the child on attaining the age of 21 years from the place of safety to the jail. It is subject to the compliance of provision of Section 20, where the children court is required to make the second evaluation to find out if the child has reformed, then to set him free and not to transfer him to the jail. But again, I'm telling you that this lapse on the part of the board members to adhere to the time limit under Section 15 of the Act will have serious repercussions for the children in conflict with law while dealing with the aspect of Section 20. Then these are the general provisions that the board are required to ensure that the child has not been subjected to any ill treatment, child-friendly atmosphere is to be maintained, participation in the inquiry is to be ensured. Then procedure for disposal of inquiry in petty offences, summary proceedings are to be adopted. In serious offences, summon procedures under the CRPC is to be adopted. And in case of heinous offences, the children below 16 years, the same procedure as in case of summon cases under the CRPC. And above 16 to 18 years, then they are required to make the preliminary assessment under Section 15 of the Act and then decide whether to transfer the child to the children court or to retain the child with itself. Then post-production processes, I can probably skip this on account of the time constraint. Then post-production, I'll just would like to share this one with you. That is Rule 10. As and when the child is produced before the board, it is required to review the available material. Now, what are the available materials with the board? At that point of time, it is the social background report and then the circumstances of apprehending the child, and can immediately pass the rehabilitative orders. So don't feel constrained that rehabilitative orders are required to be passed only at the disposal of the inquiry. Rather, the intervention in cases may be required at the very first stage, and they should undertake this intervention and pass the relevant orders under the Act. So Rule 10 also mandates that in petty offences, they can dispose of the case without waiting for the final report. So there is no need to keep waiting for the final report. They can dispose of those inquiries immediately. Otherwise, also under the Act, on termination of 6 months, they automatically lapse. Now, they can also discharge the child at the very first stage if it finds that the allegations are unfounded. Then, pending inquiry, it can release the child. direct the child to be kept in the child care institution, notify the date of hearing, seek the social investigation report, then final report. This Rule 10, Sub-Rule 6 mandates the child welfare police officer to file final report at the earliest, and in any case not beyond 2 months from the date of the recording of DDR or the FIR, as the case may be. Then there has to be participation and confidentiality, which is to be ensured. So all these things are to be taken care of. Then material which is to be considered at the time of arriving final conclusion, it is the final report, the social investigation report, the evidence produced by the parties. Then probably I'll touch upon this. This is the last aspect I would be able to cover up in the time available with me. Most of the board members were raising concern that the children who absent themselves from hearing, they are finding it difficult to bring them back into the inquiries because of certain legal issues involved there. So I want to clarify all those things. That Rule 10, Sub-Rule 3 and 4, Rule 92 and Section 26 deals with the entire aspect of this matter. Now, instead of issuing, suppose despite issuing notices, the child is not appearing, and the child welfare police officer is demanding an arrest warrant from you. Arrest warrant we can't issue. So instead of issuing the arrest warrant, they can issue the apprehension order and direct the child welfare police officers and person in charge of the police station to produce the child. We cannot undertake proclamation proceedings, and ultimately the child has to be declared missing child, and what is to be done thereafter is given in Rule 92. And remember this thing that no penal action can be initiated against the child under Section 174A IPC for not appearing before the board. So therefore, this aspect I have already requested Mr. KP Singh to elaborate tomorrow in the first lecture. Probably he'll be touching upon this part in detail. But rest assured, there's ample powers to secure the presence of the child before you during the inquiries without taking the coercive, using the accusatory terminology in case of the regular procedure under the CRPC. So I'll leave this Section 15 of the Act because Madam Madhi Panu would be taking care of it. So one of the aspects I may touch upon here is that in those cases where preliminary assessment, they say the board raised concern that it is being delayed because of the non-receipt of the final report, then Rule 10, Sub-Rule 5 mandates that there is no need to wait for the final report for conducting the preliminary assessment, and the child welfare police officer can undertake this exercise on the material available on the record. And remember this thing, there is a presumption of innocence attached during that inquiry also. Section 16 I was referring to, that the CGM is required to review the pendency of cases every 3 months. Further review in every 6 months is to be done by the executive chairperson of State Legal Service Authority, along with Home Secretary and other members. And the district magistrate may also call for any information from the stakeholders, including the board and CWC, to ensure the best interest of the child. So dispositional orders, probably I'll touch in my last lecture. Then there are miscellaneous proceedings, 22 to 26. And in this respect, the first one is that no proceedings under Chapter 8, that is security for keeping peace and good behavior, can be initiated against the child. Then there is no joint proceedings of the child in conflict with law with adult person. There was a recent direction by the division bench of our own Honorable High Court, where it noticed the concern in this regard that in those districts where there are no designated children court and the trials of adult co-accused are also being put up before the same very court, they are conducting the trial jointly, because even if the proceedings are separate, but we are giving the same date of hearing and recording the evidence in the single proceedings, it amounts to the joint proceedings. Reason for this is that the proceedings in respect of the children in conflict with law under the Act have is entirely different. We cannot ensure the child-friendly atmosphere where we are mixing up both the proceedings. There will not be a free interaction between the childrenal court and the child in that situation. So therefore, this is to be taken care of. Then there is no disqualification attached to the child in conflict with law except those tried as an adult. And there is a provision for destruction of record, just to erase and give him a fresh start. There are two deeming provisions. I will shortly touch these two deeming provisions, Section 5 and Section 6. Now, Section 5 relates to a situation where during the pendency of the inquiry, the child crosses the age of 18 years. So it simply says that it will be continued as if that person is still a child. Now, Section 6 relates to a situation where a person who has committed the offense during his juvenility is apprehended later on. Now, in this case, there may arise certain legal issues where that person is being charged with a heinous offense. In the context of Section 20, I'll touch upon this point during that lecture. So there are special. I can shift this. There are institutional bodies under the Act. I can just shortly touch this. There are child care institutions which include children home, open shelter, observation home, special home, place of safety. So these are meant for different purposes. So while passing the order, the board is required to adhere to the terminology of a given institution while lodging the child in conflict with law at a particular facility. So whether it is to be observation home, or it is to be special home, or it is to be a place of safety. So therefore, these are the different child care institutions which have been established under the Act to rehabilitate and reintegrate the children. So probably, sir, I'm over with this lecture. Probably I've exceeded few minutes. Sir, if I can